now on to sentencing in this particular case, because that is the issue here before this court. And certainly I've heard from representatives and victims of the defendant's actions, and I certainly can understand their anger and disappointment at a minimum. And there is an issue that I think the court does, that legal issue that has been briefed both by the state and by the defense in terms of, whether the court could even apply a prison sentence in this particular case. The defendant, Mr. Miswitz, through his brief, did indicate that quote the appropriate language or cite the appropriate authority, Revised Code Section 2929.13, subsection B1, which, if this is not an offense of violence, it's a felony of the fourth degree. The court shall sentence the defendant to a community control sanction, but does have the discretion to impose a prison term if any of the following apply, and the only one that would apply in this case is subsection B7, Roman numeral 7, that the offender held a position of trust and the offense related to that office or position. Defense says position as a funeral home director is not a position of trust. State says that it is, given the special relationship here and the circumstances of the relationship. I think the court does need to make a ruling on this, for purposes of appeal, etc. But I will find that given the particular situation with respect to funeral directors, that families do come to them in times of extreme need when a loved one has deceased. The planning part is kind of a business relationship in terms of planning the funeral, assessing the costs, paying for those costs. Those things are things that are set up beforehand, but that's with the intent that this is something we are not going to want to deal with when our loved one actually dies. We want all the business to be done, taken care of. So in that sense, it is a trust relationship that we're going to give you the money now up front in the hopes that when the time comes where this money has to be spent, we don't have to deal with it because we're going to have too much else to deal with. And I think that's to be expected. So in that regard, given the special circumstances of this particular case or cases of this nature, the court would find that it is a position of trust, that the funeral director is in a position of trust when he takes money, and certainly that money is to be set aside and not commingled with other assets. And I think that's pretty clear from the statements made to the court today that that's what happened here. And for whatever reason, and it's not unusual for businesses that are floundering, that they will seek to get money from any source whatsoever in order to continue the business. And maybe the intent was, I'll just take a little bit here and borrow it here and then get back up to speed and then pay it back. But that's always the case, and it always ends up hurting somebody. In this case, it hurts those people that are going through a severely emotional time to begin with, so that kind of exacerbates the whole process here. So I do feel that the court can deviate from the felony 4 and felony 5 mandatory community control sentences and impose a prison sentence. Now, whether the court will do that is the next question. The factor here that in 2911B that is courts using as its guiding principle is that the sentence should be commensurate with and not demeaning to the seriousness of the offender's conduct and its impact upon the victim. That puts us in that category where I don't think a community control sanction will adequately protect the public and not demean the seriousness of the offense, because this, I mean, anytime close to $100,000, I think we've settled on the $91,000 amount as the restitution amount. Anytime you're dealing with that amount of money that's stolen, and that's what it is, it's a theft. Normally, that would shock the conscience of most people and feel that that type of behavior should merit a prison sentence. I take some pause with respect to the defendant's medical condition, and I know I have the letter from University Hospital which says he's not in good medical shape, but I can't accept that as an excuse for mitigating the sentence. Certainly there are ways in which to handle those expenses, and actually I thought it actually is more of a burden on the state of Ohio to sentence the defendant to a prison sentence because the state is now responsible for his medical care. But even with that, because of the nature of this particular offense, the effect that it's had on so many people, and probably the I would, based on the defendant's medical condition and the amount of restitution, I don't know if that's ever going to be repaid. So in this case, I am going to find that a prison sentence is necessary in order to protect the public and not demean the seriousness of the offense. So I'm going to impose a prison sentence of 18 months on the charge of theft in count 1 and 18 months on the charge of receiving stolen property in count 2. Those will run concurrent to one another. Total term is 18 months. The defendant will get credit for time served up and through the date of transfer. And the defendant is also subject to 3 years of discretionary post-release control. And that means that upon completion of that prison sentence, Mr. Kacirek, you will be subject to the discretion of the adult parole authority. Whether or not they impose post-release control is going to be up to them. But if they do, and you are placed under post-release control, then you have to abide by terms and conditions that they set. If you do violate those terms and conditions, then you could be sent back to prison for up to 1/2 of the original sentence. I will not impose any fine in this particular case, as I'd rather have any earnings. The defendant can go to pay restitution, and I'm ordering restitution in the amount of $91,927.92 to the named victims in this case, and that will be dispersed if received by our probation department. So unless there is anything further, then before we do adjourn. Yes. Okay. One business matter that I did not attend to was to advise the defendant of his right to appeal this sentence. The court certainly advised you that you do have the right to appeal the sentencing determination made by this court. You do have the right to an appeal. If you cannot pay the costs of an appeal, you have the right to an appeal without the payment of costs. If you need counsel for an appeal, and if you're unable to pay the costs of counsel, then you are entitled to have counsel appointed for you to represent you on appeal. So those are your appellate rights. Do you understand that you have rights to appeal this sentence?
Yes, Your Honor.
Okay, all right, thank you. Then, again, if there's nothing further, then we are adjourned and defendants remanded to the custody of the sheriff. Thank you.
Thank you, Your Honor.